Hello students, welcome to the lecture on frauds committed against hotels and crimes of trespass. After this lecture, we will be able to learn the following objectives. Understand the meaning of fraud, explain the trespass, discuss on frauds. Let's start with the introduction. Trespass is an ancient set of wrongs which mainly deals with the direct and usually intentional invasion of a claimant's interest in person, his land or his goods. Trespass was one of medieval forms of action, the second being trespass on the case or simply case covered injury, which was consequential to a wrong, but the wrong was neither forcible nor direct. The distinction can still be seen in the law of torts today. Torts which are actionable per se, such as trespass to land and trespass to person, originate from all forms of trespass, while those torts which require proof of damage, such as negligence and nuisance. The law of trespass today has much of its origin in criminal law, where its function is deterrent and compensatory. Let us now discuss the meaning of fraud. Whosoever, with the intent of obtaining for himself or a third person on unlawful material benefit, damages the property of another by causing or maintaining an error by false facts or by distorting or suppressing true facts, is known as fraud. Fraud is defined as knowingly misrepresenting the truth or concealing an actual fact for the purpose of inducing another person to act to his or her detriment. Fraud is always intentional by appearance or intentional by inference from the act. Someone commits fraud if the following four elements are proved beyond a reasonable doubt. Actorist, the perpetrator, communicates false statement to the victim. Manslayer, the perpetrator communicates what she knows are false statements with the purpose of defrauding the victim. Attendant circumstances, the perpetrator's statements are false. Harm, the victim is defrauded out of property or something of value. Fraud risk assessment. A fraud risk assessment should be performed periodically to identify potential schemes and events that need to be mitigated. This document provides guidance for conducting a fraud risk assessment. However, agencies will need to make modification to meet their individual needs and complexity. Identify inherent fraud risk. Gather information to obtain the population of fraud risk that could apply to the organization. Included in this process is the explicit consideration of all types of fraud schemes and scenarios, incentives, pressures and opportunities to commit fraud and IT fraud risk specific to the organization. Assess likelihood and significance of inherent fraud risk. Assess the relative likelihood and potential significance of identified fraud risk based on historical information, known fraud schemes and interviews with staff, including business process owners. Respond to reasonably likely and significant inherent and residual fraud risk. Decide what the response should be to address the identified risk and perform a cost-benefit analysis of fraud risks over which the organization wants to implement controls or specific fraud detection procedure. Risk assessment team. A good risk assessment requires input from various sources. Ideally, management should identify a risk assessment team, even if the team would only be individual to conduct the risk assessment. Detrimental effects of fraud. The detrimental effects of fraud are loss of confidence by customers, lenders, regulators, stockholders, loss of sales, market share, influence, loss of access to financing, withdrawal or refusal of licenses, ejection of management, bankruptcy or liquidation. Condition for fraud to exist. There are three conditions which have been well publicized that are generally present when fraud occurs. The three conditions are incentive, opportunity and rationalization. Incentive. The pressure or reason to commit fraud, such as the possibility of defaulting on loan covenants, or unexpected personal bills that someone is unable to pay. Opportunity, the absence or the ineffectiveness of controls over assets or financial reporting. Rationalization allows the person to commit a dishonest act by relating it to one's own ethical values and deeming it acceptable. Elements contributing to fraud environment. The elements are too much trust in employees, lack of proper procedures for authorization, lack of personal financial information, disclosure for bank frauds, no independent checks on performance, lack of adequate attention to detail, non-segregation of duties, no separation of accounting duties.
My name is Mitchell Weiss. I teach part-time at a local university. I live with my wife outside of Hartford, Connecticut. My wife and I both make purchases online between travel arrangements and computer peripherals. And as we purchase things, we'll be entering in our credit card number to make those purchases. And like a lot of other people that are shopping online, we're aware that there's an issue with credit card fraud. And then last year, for the first time, it happened to us. There was a call from my credit card company to tell me that my card was being used suspiciously or potentially fraudulently. Would I please contact them? I looked on my email and I could see several alerts from the credit card company. My cell phone had several text messages. They're telling me that all these charges were being levied. These were in fact fraudulent charges. So they shut down my card, cleared out those charges, and I had to wait for a new card to be issued in the mail. So when I set up my account online for the credit card, one of the questions they asked was, at what level do you want to be notified when your card is being charged but not presented, not physically handed over? And the choice was over $100 or under $100. And I figured, well, if my card's going to be used fraudulently, I might as well know from $1. I want to know every charge that's being placed against this card, even if it's just for $1. So the thing that was really bizarre about this were those 4 $99 charges. It wasn't for $100, it wasn't for $50, it was $99. And apparently, according to the credit card company, that's what these folks do. They test the card with these low dollar level charges, and if the charges go through, then they go for the bigger ones. And if those go through, then they go for the even bigger ones after that. And it's a matter of how long it'll take for the credit card company to catch up with you. We still shop online. It's the most efficient way for us to get things. But we won't let the merchant store that information, even though it's a pain in the neck because you've got to enter in everything all over again. I just don't like to have the credit card stored. I don't think that anybody can be perfectly comfortable that this is never going to happen. Does it deter us from shopping online? No. We're still going to shop online. We're still going to make our purchases, make our travel arrangements, do the things that we need to do.
Let us now talk about trespass. Trespass involves intentionally or negligently entering or remaining on or directly causing any physical matter to come into contact with land without the permission of the owner or lawful occupier. Therefore, to enter another's property without permission is a trespass. The civil tort is to protect the interests of others in maintaining their land free from any physical intrusion. Trespass to land. Trespass to land is actionable per se, which means that the party whose land is entered may sue even if no actual harm or damage is done. However, where damage can be proven, the amount of compensation which the owner or occupier may recover will be increased. Defenses to trespass. The defenses to an action in trespass are the authority of law. A police officer entering onto a land pursuant to some legal power, a bailiff entering onto land in the course of their duty, fire brigade if they are trying to stop a fire, licensed surveyors with a genuine need to carry out a survey. Abatement of a nuisance. A person who enters a property to stop a fire spreading. The permission to enter into the land which is given by the person entitled to possession, ejected from the property using sufficient force only. The party in possession of the property, such as the occupier, can eject a trespasser from the property, but is not allowed to use any more force than is necessary. Generally, no force is necessary to eject a trespasser. However, if the trespasser uses force during or after the entry, the occupier is then justified in using a similar force to protect themselves and the property. An injunction to restrain a continuing trespass. Continuing to remain on the property of caused rubbish to remain after initial trespass or to prevent a threatened trespass. Court action for damages. If any damage is caused on the property during an act of trespass, the party in possession of that property may sue for damages. Evidence collected during trespass, a court proceeding. If we obtain evidence during an act of trespass, we will not normally be allowed to rely on that evidence in court as it has been illegally obtained. The judge has discretion as to whether or not to allow evidence obtained during an act of trespass to be relied upon. Publication. Injunctive relief is also available to the plaintiff to suppress the after effects of trespass, such as the subsequent publication of evidence such as a videotape, film, photograph or interview obtained by a trespasser during the course of the trespass. Duties of trespassers in hotels. Property owners are liable for maintaining both the inside and outside of their premises. A hotel owner has a duty to maintain not only the rooms and common areas inside the hotel, but also the sidewalks, entryways and parking lot outside of the hotel. Slip and fall cases are some of the most common premises liability suits brought against business owners. Criminal trespass. At common law, a trespass was not criminal unless it was accomplished by violence or breached the peace. Some modern statutes make any unlawful entry onto another property a crime. When the trespass involves violence or injury to a person or property, it is always considered criminal and penalties may be increased for more serious or malicious acts. Trespass to goods. Trespass to goods affords a remedy where there has been a direct interference with goods in the claimer possession at the time of the trespass, whether that be by taking the goods from him or damaging the goods without removing them. Trespass and conversion deal with intentional interference with goods. Essentials of trespass to goods. Possession. A person in possession, though not the owner, can sue. Title of third person. Self-defenses. Rightful claim. Authority of law. Consent. Negligence of the plaintiff. Reception of goods. Wrongful act other than a breach of contract that injures another and for which the law permits a civil non-criminal action to be brought. Relief may be obtained in the form of damages or an injunction. The term derives from Latin tortum, meaning something twisted, wrong, or crooked. Assault, defamation, malpractice, negligence, nuisance, product liability, property damage, and trespass are all apart from their potentially criminal and contractual aspect torts. Elements of torts. Tort is a remarkably wide-ranging subject and probably the most difficult of all legal areas to lay down all-embracing principles. The approach that will be taken at this stage is to lay down a general pattern and then to show some of the main deviation from this pattern. The basic pattern. The paradigm tort consists of an act or omission by the defendant which causes damage to the claimant. The damage must be caused by the fault of the defendant and must be a kind of harm recognized as attracting legal liability. Variation. The element of act or omission and causation are common to all torts. There are certain torts which do not require fault. These are known as torts of strict liability. The interest protected. Personal security. People have an interest in their personal security. This is protected in a number of ways. If one person puts another in fear of being hit, then there may be an action in the tort of assault. If the blow is struck, then the person hit may have an action in the tort of battery. A person whose freedom of movement is restricted unlawfully may be able to sue for false imprisonment. If personal injury is caused negligently, then the claimant may have an action in the tort of negligence. Interest in property. Property in the broad sense of the word is protected by tort law. A person has an interest in their land which is protected by a number of torts such as nuisance and trespass to land. Interests in personal property are protected by torts such as trespass to goods and conversion. Where clothing or a car is damaged in a negligently caused accident, then a person may have an action for damages in negligence. Economic interest. Tort law will give limited protection to economic interests where the defendant has acted unlawfully and has caused economic loss to the claimant. These are known as economic torts. Such protection is limited because the common law has been cautious in drawing the line between lawful and unlawful business practice. This is a line which is largely left to statute to draw. Reputation and privacy. Increasingly important are a person's interest in their reputation and privacy. Where a person's reputation is damaged by untrue speech or writing, then they may have an action in the tort of defamation. There is no specific tort to defend privacy, but there have been some interesting development in this area. The role of policy. Lawyers are used to dealing in concepts such as duty of care, remoteness of damage and fault, etc. When cases are analyzed in these terms and there is held to be no liability as there was no duty or the damage was too remote or the defendant was not at fault, this is referred to as formal conceptualism or black letter law. What is frequency concealed in this terminology is the policy reason behind the decision. The role of insurance. Without insurance, the tort system would simply cease to operate. Where a claimant is successful in an action, the damages will normally be paid by an insurance company. In cases of property damage, insurance may take the form of loss or first-party insurance, which covers loss or damage to the property insured from the risk described in the policy, whether or not the loss occurs through the fault of another party. There is also liability or third-party insurance. This is a matter of contract between the insurer and the insured, whereby the insurer promises to indemnify the insured against all sums. The insured becomes liable to pay as damages to third parties. The third party must establish the insured liability to them. Malice. Malice in tort has two meanings. It may be the intentional doing of some wrongful act without proper excuse, to act with some collateral or improper motive. Intention. The meaning of intention varies according to the context in which it is used. Intention is relevant in three groups of torts. Torts derive from the writ of trespass. Here, intention means where a person desires to produce a result forbidden by law and where they foresee it and carry on regardless of the consequences. The defendant must intend to do the act but need not intend harm. In cases of fraud and injuries, falsehood, in these torts, the defendant must make a statement which they know is untrue. In cases of conspiracy, if X and Y combine together and act to cause injury to Z, then Z will have an action provided that they can prove that their primary motive was to cause them damage. If the primary motive of X and Y was to further their own interest, then even if they realize that their act would inevitably damage Z, they will not be liable in conspiracy. Negligence. Negligence in tort has several meanings. It may refer to the tort of negligence or it may refer to careless behavior. It is in the latter sense that the word is used here. In this sense, it does not refer to a state of mind. When a court finds that a person has been negligent, it is making an ex post assessment of their conduct. Objectives of torts. Tort law has two main objectives: compensation and deterrence. Deterrence. Deterrence is of two types: individual deterrence. The theory behind individual deterrence is that the possibility of a civil sanction such as damages will cause the defendant to alter their behavior and avoid inflicting damage. General or market deterrence. Academic work on the economic effects of tort liability rules has renewed interest in the role of deterrence in tort law. This form of deterrence is not individual deterrent but what is known as market deterrence. Compensation. One of the major aims of tort law is to compensate those who have suffered personal injury. The present system shifts losses from the claimant to the defendant when the defendant has been shown to have been at fault. In recent years, this system has come under increasing criticism as being an inefficient method of compensating accident victims. Tort of conversion. Whenever a person wrongfully possesses or uses the personal property of another without permission, the tort of conversion occurs. Any act that deprives an owner of personal property or the use of that property without that owner's permission and without just cause can be conversion. Even the taking of electronic records and data can be a form of conversion. Acts of conversion. The acts of conversion are when the property is wrongfully taken, when it is wrongfully parted with, when it is wrongfully sold, when it is wrongfully retained, when there is a denial of the lawful owner's right. Conversion by denial of rights. Conversion by delivery. Difference between conversion and trespass. Following are the major differences between conversion and trespass. Trespass to goods means just interference with the possession, not of ownership. A mere taking or aspiration is actionable to a trespass, but every aspiration is not trespass. While trespass is an unlawful taking which may be for the sake of removing the property. Conversion is an unlawful taking for the purpose of exercising adverse dominion over it. Conversion is wider than trespass because in an action for conversion, the plaintiff need not prove actual possession but can show if he had an immediate right to possess. Trespass is a wrong to possession. Trespass cannot be committed by an actual possessor, but an actual possessor can be sued for the conversion by the person who has the immediate right to possess. Now in the end, let us summarize what we have learned in this lecture. Fraud is always intentional, intentional by appearance or intentional by inference from the act. Trespass involves intentionally or negligently entering or remaining on or directly causing any physical matter to come into contact. Trespass to land is actionable per se, which means that the party whose land is entered may sue even if no actual harm or damage is done. Property owners are liable for maintaining both the inside and outside of their premises. A tort is a civil wrong in the sense that it is committed against an individual, which includes legal entities such as companies rather than the state. Tort is a remarkably wide-ranging subject and probably the most difficult of all legal areas to lay down all-embracing principles.